right. So, what is estate planning? I always like to start with this question just to break it down into simple formation because the example of what estate planning is also mimics what a living trust actually does. And so I've broken it down really into three basic elements. And the first element of estate planning is creation of one's estate. This is something that we're all doing, because we're here and we're accumulating assets. And it's very normal that once we have assets accumulated, we're going to worry about managing them, preserving them, and then what do you want to do with them? So my point of bringing up the elements of estate planning is simply to mention that in the future, when we talk about the trust, you'll notice that the trust follows these elements. So in other words, having a trust is nothing more than what you're already doing anyway. Now, one of the key elements that we're going to talk about today is how to keep our affairs private versus how to have our affairs public. And what I mean by public is we have to go to court. And the whole idea is not to go to court. And one of the biggest problems with doing nothing when it comes to estate planning is it does drag us into court. And one of the biggest areas that we have a problem with are fees. And so what we want to do is eliminate those fees because we simply do so by eliminating going to court. Another area of estate planning that we're not going to get into today, but I just want to mention quickly, is estate planning does deal with taxes and the payment, especially of estate or death taxes. This is called advanced estate planning, and I always like to show this chart here just to give you a quick idea of what I'm getting at. It's really for the very, very wealthy. And we do very wealthy estates when it comes to estate planning. I like to show this chart because it gives you an example of who did something right and who did something wrong. Elvis is always a great example of what not to do when it comes to an estate plan. Here's a gentleman that ended up having nothing in writing upon his untimely death, and as a result of having nothing in writing, he immediately, or his family, his estate, lost $7 million as a result. Now, both Rockefeller and Disney, they did have certain estate planning documents, trust involved with their estate. And as you can see, they were able to keep, money within their family structure, but not as much as they could or should have. And the one we always like to brag about is Kaiser. Here's one with $56 million estate. And as a result of his good planning, the $55 million were actually kept within his family structure. So the moral of the story here is if you do have a lot of money and you have a large estate, large assets, do give us a call and I'll be happy to go over estate planning with you when it comes to advanced estate planning. However, today we're not going to talk about what the wealthy do. We're going to talk about what everybody has to do when it comes to setting up one's own private estate. And in California, we really have three choices. You can do nothing when we call that intestate succession. If you do nothing to plan your estate, believe it or not, the state of California does have it all figured out for you. They have their law books, and those law books are going to dictate, who your heirs are and how much everybody's going to get. But if you think about it, if you're going to allow the state of California to dictate who your heirs are and how much everybody's going to get, you don't have a say-so. So in order to gain your own say-so, your own private distribution plan, you have to have a writing. And the first level of having a writing is a will. And at least with the will, what you now have is a written instruction to the court outlining who your heirs are and how much everybody's going to get. But the operative word here is court. So you'll notice that if you do nothing to plan your estate, or if you choose just to do a will, you're in the public arena. In other words, we have to go to court, and all the fees that I initially mentioned all kick in as a result of that. Now, the opposite of going to court and keeping your affairs private is the living trust. Living trusts are very popular on the West Coast, especially in California. Anybody that simply owns a home or has more than $166,250 will find themselves in a probate situation. So in order to avoid that, you use the living trust as your estate plan. Now, a lot of people ask me what probate's all about, and I always assume everybody kind of knows. However, what probate really is if I pass away, I am not here to sign title changes down to my family, which simply means how do you perfect a clean title down to the next generation? Well, you need to go to court and get a judge's order. That's what probate's all about. And of course, the exception is the living trust, and we'll get into why that is. But once you're in court, that's when all those fees kick in that we initially mentioned. And I always like to show this chart up here to give you a quick idea what those fees are. This chart is out of date a little bit in the sense that the $150,000 that kicks off the first attorney fee level is now up to $166,250. So the first $166,250 of any gross estate going through the probate process equates to a $4,000 attorney fee. Then at $266,250, you're going to have a $7,000 fee, and then my fee continues to climb $2,000 for every additional $100,000 of gross estate that you have going through the probate process. And you'll note that probate is all geared up on gross estate, not net. If you have a $500,000 home and a $250,000 mortgage on it, it does not matter in terms of my fees. I get paid on the full $500,000 value of that house. And then you may be thinking that these fees are a lot, and they are. However, they're only half. In fact, they're not even really half when it gets down to it. What I'm getting at is this, that every executor who handles your estate also is entitled to the same fee that the attorney gets. So everything on the right column there under attorney fees doubles. Half goes to, or I should say one amount goes to the attorney, one amount goes to the executor, and then you know you can't go into court for free, right? You always have to pony up a filing fee, a notice of publication of death fee, usually a probate referee fee, and good old California's figured out how to charge you to close the estate. So there's a closing fee now when it comes to probate. All these fees typically add up to around $2,200, and then you have the attorney fees, and then you have the executor fees. So the moral of this story is simply to stay out of court. If you stay out of court, you naturally avoid all these fees. But the quickest and easiest way to get into these court problems and these fee structures is, once again, to do nothing. And we call that intestate succession. Again, intestate succession is an estate plan by default, in the sense you're defaulting to the state of California to figure out who your heirs are and how much everybody's going to get. So that's what I mean by the bullet point up here, calling the fact that it does require probate. We do have to present ourselves in front of a judge in order to pass that clean title. And then what I mean by no guarantee is you don't have a writing, so the judge has total discretion to figure out who your heirs are and how much everybody's going to get. So if in fact you want to say so, the first step is having a writing, and that first level of a writing would be a will. However, as we mentioned before, a will is nothing but an estate plan outlining who your heirs are and how much everybody's going to get for the court. So the bottom line with the will is we have to go to court. We have to have a judge basically pass orders in order to pass a clean title down to the next generation. Now, the advantages of a will is it does cost a little bit less to get started than, say, getting a full trust package, because naturally you only get a will when it comes to getting a will. When it comes to getting a trust, there are a package of other documents that makes everything work, which we'll go over here in a moment. But a will is also simple during lifetime. There's nothing to think about. Usually when we do a will, we get it done, we put it into, the file cabinet at home, and we forget that it's there. And the next thing you know, 20, 30 years later, and I'm not exaggerating, we think that about it again, and we pull it out and notice that it's all completely out of date. The reason I mention this is because a lot of times I am going into court on probates simply with a very old will. And a lot of times that will not reflect the current family dynamics. You know, you might have more children that you've accumulated, or you have less children that you've accumulated, or you might have even changed spouses along the way. Now, that may sound funny, but one of the biggest fights I always get into in court is when a will pops up that has an ex-spouse as, your beneficiary, and then yet you have a new spouse now and maybe even a new family, and they're all arguing with the old family as to who's supposed to get what. So I guess the moral of that story is if you are going to change spouses, do not forget to change your estate plan. With that, number 3, guaranteed results. What I mean by that is you do have a writing, and the judge has the ability to follow that writing. But again, a judge also has discretion to change the writing once we're in court in order to match the family dynamics if that will does not adequately reflect who your family really is. So the disadvantages of the will is everything I've kind of been emphasizing up to this point. It does require probate. That means we have to go to court and spend the money that I showed you on that chart. And the other big problem is it takes forever. Right now, a normal probate will take about a year to get through the system. Now, if there's any arguments or any challenges to anything, it drags out to 2 or 3 years in order to get through, the probate process. Now, it all depends on the courts that we're filing at. Downtown Los Angeles has consolidated all of the outlining Los Angeles County courts into downtown LA for probate, which means they have a very large docket and they are very busy, and it takes forever to get through the Los Angeles court system on a probate. About 2.5 years seems to be my average at this point in time. San Bernardino is a complete mess right now in terms of how probate is being run. They seem to be having problems with filing documents, say, on the second floor and it not being scanned. That's the word they're using, scanned into the court file on the 10th floor. So by the time I get around to appearing, there appears to be a lack of documentation in the judge's file, which invariably means that the judge more than likely is going to continue it. And continuance caused more delays, and so we're having issues with San Bernardino at the moment. However, Riverside County is running very smoothly. They do have their act together. San Diego does, and so those courts are actually working fairly well at this point in time. Again, I emphasize this because a lot of times preparing and filing paperwork in court doesn't necessarily guarantee a smooth transition. There's a lot of other factors involved when it comes to going into court, and that includes how the court is actually being run internally. So with that, the disadvantages of a will does require the probate. We have to go to court and spend the money to be there, and we have those substantial time delays that do have a way of cropping up, and depending on which court we're acting in, take longer than another. So with that, I've kind of gone through the general rule of what the opening presentation is all about. And that is, if you decide, to use a will or do nothing, we're going to end up in court, and it is going to take, anywhere from a year to 2.5 years to get through the system before anything actually gets resolved. Now, there are exceptions to this general rule, one of them being joint tenant titling, and then small estates, and then the living trust itself, of course, is an exception. Now, joint tenancy is a way of holding title. It is not an estate plan, and a lot of people try to use joint tenancy as an estate plan. I highly recommend you don't really do that because, well, bottom line is joint tenancy is something that we do when we first get married and we first start buying properties together. We like joint tenancy because it has a right of survivorship. So that means upon the death of one, it automatically goes to the other, and you don't need a will or a trust or anything in that regard. However, there is a benefit for husband and wives having a living trust, and then it has to do with a tax consequence when it comes to a stepped-up tax basis. In joint tenancy, only the decedent's half interest steps up upon their death, to raise the basis in your property, which gets rid of capital gains taxes. The survivor's half does not step up. So if you're a surviving spouse in joint tenancy, you can sell the property at that point in time because, well, you own it. However, you will have a capital gain hit. If you use a living trust between husband and wife, on first death between spouses, both halves step up, which means the surviving spouse now can downsize and consolidate, get rid of those rental properties maybe at that point in time without paying a capital gains tax because both halves step up upon the death of one. And then on second death, one of the beauties of having a living trust too is there is another step up that occurs on the basis of the property, which means your children can turn around and sell that property without a capital gain hit. Now, joint tenancy, when it's not used properly, in other words, you try to use it as an estate plan, that's usually when things cause a problem. Joint tenancy may be okay between husband and wife, except for what I just talked about. But what happens when you're a single surviving spouse? You're going to have a probate. You can't have joint tenancy unless you start putting sons and daughters on properties as a joint owner with you. And you don't want to do that. You actually do a disservice to your children by putting their names on your deed to your house, for example, because, once again, when you pass away, the other half does not, and there's not a stepped up tax basis that occurs, and you're bootstrapping your children into a capital gains tax hit. If you have any questions on that, please give us a call or come in for a free consultation, and we'll be happy to go over that with you with maybe a better explanation. But the other exception to probate is small estates. Now, there's two triggers for probate in California. Once again, it's real estate. A piece of land always is going to trigger a probate, or more than $166,250 of personal property. Now, real estate does have different levels of probate that we can get involved in based on the value of the estate. You know, if it's under $55,000, we can usually get away with an affidavit of death and not have a full-blown probate. If it's between, I should say the real estate is valued between $55,000 and $166,250, we can do a small type probate. If it's over $166,000 in value, then we do have to go into a full-blown probate on that. So when you come in and talk to me about a probate for your family, we always value the properties and see which category of probate you fit into. If you do have a small value on a piece of land, maybe we can do something less than a full-blown probate. So that brings me to the living trust itself. And before I get into that, I always like to show this slide here just to kind of give you an idea that I do have a lot of clients in my office that will set up their living trust simply to avoid probate on the house, even though they do not have enough money in the bank to actually trigger the probate. So the first question I always ask folks when they come to see me is, do you have a house? And if they say yes, then I know they need that estate plan designed around a living trust. Real estate is really the trigger in California when it comes to using a trust versus not using a trust. Now, I show this slide here because this was a lady who just refused to do the living trust, didn't listen to her family who were trying to get her involved in it, and sure enough, at some point she did pass away. And as a result, instead of having a clean end to her life in the sense of passing the family down with the house very easily, we had to go to probate. And as you can see, it took me more than a year to get through the probate process, and a full cost of $9,000, which is way more expensive than if she would have just done the living trust in the first place. So I do want to emphasize that those of you who do just have real estate that's going to trigger the need for a trust, yes, you still need to get that trust set up in order to avoid probate on that real estate.